Para for dictation, 5 seconds to start. 5, 4, 3, 2, 1. Briefly stated, the relevant facts are that the marriage between appellant and respondent was solemnized according to Hindu rites and rituals on 4th August 2000 at Shillong. The parties knew each other prior to their marriage as they had been working together since 1992 as development officers under Life Insurance Corporation of India Limited. Full point. Para. According to the respondent wife, though the appellant husband knew the nature of respondent's duty and responsibility in their office, even before their marriage, yet the appellant and his family members demanded the respondent give up her job, ignoring the fact that she had to financially look after her old and ailing mother, her brother and other dependents. Full point. It is the respondent wife's case that due to the continuous ill treatment meted out by the appellant and his family, respondent wife was compelled to leave her matrimonial home in 2001. Full point. The question which falls for consideration in this appeal is whether there is an intentional, permanent forsaking and abandonment of one spouse by the other without the other's consent and without reasonable cause. Sign of interrogation. It is a well settled proposition of law that in proceedings for divorce, the plaintiff must prove the offense of desertion, like an other matrimonial offense, beyond all reasonable doubt. Full point. In my opinion, the respondent is unable to clinchingly establish that the appellant has deserted him. The evidence led by him are absolutely insufficient to prove desertion. Full point. Para. According to his evidence, after the appellant deserted his house, he along with his family members and some of his friends tried to patch up their differences, in which she had proposed that if he would not keep his mother with him, then and then only she could come back to him, which he refused to oblige. Full point. This evidence of the respondent, who examined himself as PW7, is conspicuous by the absence of details such as the date, time and place when such reconciliation attempt was made by him. Full point. If the appellant had made her return to her matrimonial home conditional upon the abandonment by the respondent of his mother as alleged by him, this could amount to an unreasonable refusal on the part of the appellant to go back to her husband. But none of the 6 witnesses examined by him corroborated him on this point. Desertion is matter of interference to be drawn from the facts and circumstances of each case. Full point. Not an iota of evidence has been adduced. Stop.